So at that time, you became aware that y'all had taken a position previously not to intervene in the lawsuit?
That's what waiver means. When a notice is sent to our office per statute, if there's a charity involved in litigation, they're required to notify our office of that and give us an opportunity to intervene. We'd received that notice and we had issued a declination of waiver.
In your conversations and research, did you discover when it was chronologically that the office had previously declined to enter the litigation at all?
My recollection, it was early in 2020, perhaps as early as January.
All right. And so after that declination, what did you learn? What was the occasion for this issue coming back before you?
My impression was it was the Attorney General asking me to review the file. And
at that time, did you discover how long the litigation between Mr. Paul's companies, therefore Mr. Paul, and the Media Foundation, how long had they been in litigation by that time?
It had been a long and sordid affair, yes. Lots of litigation had taken place.
And was it more than 1 year?
I believe it was more than that. I'm testing my memory, but it had been the case file was well developed.
All right. So at the end of the time, once you talked to him and once you talked to Mr. Godbee and you reviewed your other materials, what'd you do next?
Well, I notified the Attorney General that we had waived. We had previously waived on the file.
And did you have a recommendation as to whether you continued that waiver?
Either at that time or subsequent to that, I did. I had looked at the file. My strong belief, and by the way, this is very common, we rarely intervene because oftentimes the factors for intervention are
non-responsive.
Let me ask you, what was your opinion after you talked to Mr. Godbee and looked under the circumstances? By the time you talked to the Attorney General, what was your opinion as to what you should do?
There was no basis for us to intervene in the case.
Did you have that recommendation to the lieutenant? I mean, did you have that?
I would object again.
I'm not suicidal, Your Honor. I'm not, I promise. Did you have that, did you share that opinion with the Attorney General?
My recollection, yes, I did share with him what had happened. The waiver had been filed, and the reason for the waiver was there was no basis for us to intervene.
What was the Attorney General's reaction?
He was not happy with that response.
How did he show he wasn't happy?
He informed me that he was surprised and not happy that we had waived. He wanted me to reconsider the waiver. He informed me that in his view, it was improper for a charity to be oppressing a business, especially when the charity was effectively a limited investor in the business. He thought that was out of bounds for a charity to do that. And it was his view the litigation was somehow a form of oppression by the charity toward the business.
So if one were to ask, had he taken a clear-cut position on one litigant against the other in the case?
He was determined for us to intervene, and the basis for that was he was concerned that the charity was doing wrong to the world class.
And did he express any kind of feelings of himself against Mr. Godbee's thus far resistance to entering the litigation?
Yes, Mr. Godbee was resistant to entering into litigation. He and I had many conversations to that effect. We were both in agreement that intervening was a poor choice and was not justified by the circumstances.
It was the position that made its way to the Attorney General.
Yes.
How would you describe why you and Mr. Godbee had concluded that you should not change the earlier decision and should not intervene in the lawsuit?
The charity was represented by competent and able counsel. It was taking legal positions that we believe were justifiable. It was largely, from our view, doing well in the litigation. The litigation involved a request for World Class to produce books and records concerning the investments the charity had made, and World Class was refusing to provide those, which any good corporate lawyer knows is improper. And so the charity was defending its interest in its investment aggressively and appropriately.
And was the charity itself simply seeking to find out what the value of their investment was?
Yes. Among other things, yes.
And among that and others, and whatever expenses that had been incurred when y'all looked at the file, who was causing the expenses?
The litigation had, when I earlier said it was a long and sordid affair, what I meant by that was World Class was rapidly burning through law firms. It had developed a history of using law firms, not paying their bills, cutting them loose, going on to the next law firm. So it was using law firms at a frightening rate. It was filing a number of motions. It was resisting discovery into its books and records.
Objection or non-responsive?
No, it is responsive. That's exactly what I'm asking. What was happening with the assets, and which one of these two parties was causing the expenses?
To our witness, just try to answer the questions directly moving forward.
Yes, Your Honor.
All right. Now, at the end of the day, what would you describe the dispute being a minority investor invested with a company, Mr. Paul's companies, and they can't get any records, books or records to tell them what the expenses are, what the value is or so. And so there's a lawsuit. Is that a fair resolution? Fair description?
That is my understanding of the basis for the lawsuit,
All right.
yes.
And so when all this was going on, once you told the Attorney General that you and you agreed with Mr. Godby and you should not interfere, what happened?
He effectively directed us to intervene. He directed us to intervene.
He instructed y'all to?
Yes.
So did he interfere in a lawsuit? Did that interference, did that ultimately turn out to be on the side and effect of Mr. Paul?
Objection to leading.
How did it
Sustained.
All right. How did it end up? I mean, was there anybody that benefited from that by the fact that the Attorney General's office came in?
Yes.
Objection to speculation and an improper opinion, Your Honor.
What?
Sustained.
Well, you clearly, though, knew what the result was going to be, did you not?
Objection to improper opinion and speculation.
Me, just let me finish, please. The question.
Let him finish the question.
Judge.
Thank you. When you were opposed to the intervention, whom did you believe would benefit from the intervention?
Objection to speculation and improper opinion.
I've asked what his opinion is. That's very relevant here.
And I'm objecting to the opinion.
Excuse me.
Overruled.
Thank you. Whom did you believe would benefit from the intervention?
It was clear to me that the intervention...
Keep your microphone, please.
It was clear to me the intervention would benefit World Class Holdings and Nate Paul.
All right.
There was no question about that.
And what was your position expressed to the Attorney General as to whether that was appropriate or not?
It was not appropriate.
All right. In spite of that, there was an intervention?
There was an intervention. I was directed by the Attorney General to do so. I instructed Josh Godby to make the intervention. We justified it on the basis that we would intervene for the purpose of bringing the parties together for a mediation. That's honestly how I put lipstick on that pig.
What was your knowledge as to where there'd already been one mediation that was unsuccessful?
Yes, there had been.
Had there been an agreement previously?
Yes.
And do you remember how much at that mediation that there was an agreement for that the Midi Foundation would receive?
Yes.
How much was that?
My recollection was around $10 million.
And then was that agreement breached?
Yes.
By whom?
World Class.
And by the time that y'all were asked to intervene or instructed and ordered to intervene, what was the status of the litigation?
The Midi Foundation was pressing, based on my recollection, they were pressing hard for discovery into World Class, and World Class was approaching a point where they were risking sanctions for discovery noncompliance.